Hello and welcome to AI TV News. In this segment, we're breaking down a major court ruling on birthright citizenship in the United States. A federal appeals court has dealt a significant legal blow to the Trump administration, ruling that the president's executive order to end birthright citizenship is unconstitutional. This decision from the Ninth U.S. Circuit Court of Appeals upholds a lower court order that already stopped the policy from taking effect nationwide.
So, what does this all mean? Let's break it down. First, what did the court say? In a 2-to-1 decision, the court stated that the executive order goes against the clear language of the 14th Amendment to the Constitution. That amendment grants citizenship to all persons born or naturalized in the United States and subject to the jurisdiction thereof. This is the first time an appeals court has ruled on the constitutionality of the order itself, making it a landmark moment in this legal fight.
To understand the significance, we need to go back to January 20th, 2025. On the very first day of his second term, President Trump signed an executive order to change a practice that has been in place for over 150 years. The order aimed to deny automatic citizenship to children born in the U.S. if their parents are not American citizens or green card holders. This would affect children of parents who are undocumented or in the country on temporary visas like student or tourist visas.
The administration's argument centers on 5 words in the 14th Amendment, subject to the jurisdiction thereof. They claim this phrase excludes the children of parents who are in the country illegally or temporarily, arguing those parents do not have full allegiance to the United States. This interpretation, however, departs from a long-standing legal understanding. The 14th Amendment was ratified in 1868 after the Civil War, primarily to grant citizenship to formerly enslaved people. Its interpretation was solidified by a key Supreme Court case in 1898, United States v. Wong Kim Ark, which affirmed that a child born in the U.S. to Chinese immigrant parents was in fact a U.S. citizen. This principle is known as jus soli, a Latin term for right of the soil.
Immediately after the president's order was signed, it was challenged in court by civil liberties groups, several states, and even expecting mothers. Federal judges quickly blocked the order from being enforced. The legal journey then got more complicated. The administration appealed to the Supreme Court. But in a ruling last month, in June 2025, the Supreme Court did not decide on whether birthright citizenship could be ended by a president. Instead, it issued a procedural ruling that limited the power of lower court judges to issue what are called nationwide injunctions, broad orders that block a policy across the entire country.
That Supreme Court decision, however, left a couple of pathways open for opponents, and that brings us to this latest ruling from the Ninth Circuit. The case was brought by 4 states, Washington, Arizona, Illinois, and Oregon, who argued that if the policy were blocked in some states but not others, it would create chaos as people move between states. The appeals court agreed, stating that a nationwide block was necessary to provide the states complete relief.
The White House has said it disagrees with the court's interpretation and plans to appeal. Opponents of the executive order have called the ruling a major victory for the Constitution. So, what happens next? The administration could appeal to a larger panel of the Ninth Circuit, or more likely, appeal directly to the United States Supreme Court. This latest decision makes it increasingly probable that the nation's highest court will have to step in and rule on the fundamental question at the heart of this debate. Can a president use an executive order to change who is considered a citizen at birth? For now, birthright citizenship remains the law of the land, and the nationwide block on the president's policy stays in place.